Hello friends, I am Meenu Agarwal from Delhi NCR, practicing chartered accountant by profession. I would like to extend my gratitude to Vivek sir and to his entire team for giving us this opportunity to share knowledge and discuss on certain important and technical matters. So today's topic is going to be landmark judgment by the Hon'ble Supreme Court in case of taxability of software. The Honorable Supreme Court has concluded on the taxation on the use of taxation on the payment towards the use of software in case of Engineering Analysis Centre of Excellence Private Limited versus CIT. The Supreme Court has concluded more than 80 appeals in this decision to understand whether the use of software should be treated as royalty or not. Before we proceed with understanding the judgment, let us understand what is royalty. In a very layman language, royalty is nothing but a consideration by a person, a creator or innovator, for allowing his work to be used or to be analyzed for any artistic or a scientific work. So any payment that you make to such user, whether such payment will always result in royalty or not, is a subject matter in this judgment. Now, this matter has been in dispute, and there have been lot of conclusions over a lot of decades, over a period of decades. There was no particular conclusion in this matter, but in this decision, the Honorable Supreme Court has come out with a very concrete decision, which is going to be useful for a near future. Let's understand what was the key issue in this case. In this case that was brought before the Honorable Supreme Court, the key issue was that whether the payments that are made by the Indian resident end users or the distributors to the non-resident software manufacturer or suppliers for the distribution or use of computer software should be treated as royalty as per the provisions of the Income Tax Act or the Double Taxation Avoidance Agreement as applicable, and accordingly tax should be deducted under Section 195 of the Act. This was a concern which was brought before the Supreme Court, not only in one case but more than 80 appeals. Now, different SSCs, there will be a different background, different business model. To ease the understanding and to arrive at the conclusion, the Supreme Court grouped these business model into four categories. The first category was where the Supreme Court identified that in the first category, the Indian distributor shall purchase the software from the non-resident supplier for sale to the Indian users. In category 2, the Indian user shall directly purchase the software from the non-resident suppliers. In category 3, those assessees were classified wherein the Indian users directly buy the integrated software from the non-resident suppliers. In the last category, those assessees were classified or grouped wherein the non-resident distributor first purchases from the non-resident manufacturer and further sells it to the Indian distributor or the end user. So in all the appeals, the main matter was that whether such payment, which is for the purchase of software, which is for the use of software, should be treated as royalty and tax should be deducted accordingly under the Act or as per the DTAA. The judgment by the Supreme Court was not based only on the definition of royalty as per the Income Tax Act or as per the Double Taxation Avoidance Agreement. The Supreme Court went on to understand and analyze the various other matters which shall have impact on such transaction. So the analysis was done even with respect to the Copyright Act, the analysis of the end user agreements or the license agreement or the distribution agreement were made. Even the Supreme Court went to the extent of analyzing whether the OECD Model Tax Convention Commentary, Article 12, shall have any impact on this transaction, or can we draw some inference over there to arrive at a conclusion. This judgment of the Supreme Court runs into 226 pages. hats off to Supreme Court for having such patience, such tolerance of not only understanding, not only analyzing the definitions of the Act, but going to the extent of analyzing all the above factors. So we are going to understand what was the basis and how did the Supreme Court went about the judgment. The first contention of the revenue was that to deduct TDS under Section 195, should a payer who has a onus or who has a responsibility, should that payer analyze the provisions of DTAA at that stage itself, or it should be treated as a preliminary partake and not a final assessment? The revenue also placed it reliance on the apex court judgment in case of Pilcom. The conclusions, the facts of the Pilcom was that there was a payment made to the non-resident sportsman under Section 194E of the Act at the rate of 20%. We'll see how Supreme Court concluded on this. Now, this contention was not very welcome by the Supreme Court for the reason that the apex court itself has concluded in the case of GE Technologies whether DTA need to be considered at the time of deduction of tax under Section 195 or not. It concluded that the machinery provisions of 195 are nothing but they are linked with the charging provision, and hence TDS need to be deducted on those sums which are taxable under the provisions of the Act read with DTAA. So when there is a judgment already, why again this was come up? That was little surprise, but still Supreme Court went on to analyze this provision and concluded that yes, at the time of deduction under 195, you have to consider whether DTAA shall be applicable or not. Now, when coming to the Pilcom decision, which the Supreme Court itself had taken, the Supreme Court identified that the facts of the case should be same if you're placing some reliance. Supreme Court held that 194E language is totally different from that of 195. In 195, a onus is given on the payer to see if the transaction is taxable in the Act or not. So when it says Act, it does not mean that you cannot refer to DTAA. In the Act, read with DTAA, you need to consider and then come to a conclusion. The Supreme Court also, discussed two circulars. Circular wherein it was clarified that a chartered accountant need to issue a certificate whenever there is a payment to the non-resident. In this certificate, if one recalls what is the format of this certificate, it clearly gives a comparison between the provision of the Act and provision of DTAA. As it is said that the circular is binding on the department, was not very sure as to why this point was held for discussion under this judgment. Going ahead, the revenue also contended that the definition of royalty via explanation 4 to section 916 of the Act includes the transfer for the use or right to use of the computer software. Now, the Supreme Court went on to, so the revenue contended that because it is already included in the Act specifically, there is no question of any dispute, and hence such use of software should be concluded as payment towards royalty, and TDS should be deducted without any DTAA benefit. But the Supreme Court here also went one step of understanding and analyzing the definition. You will see how. The first point what the Supreme Court analyzed was the punctuations, the importance of punctuations in any sentence that you have. For example, if you see, I have highlighted the word copyright, comma. If you read this, it says that transfer of any rights in respect of copyright, as if it is an element in which you transfer such rights. But the Supreme Court said that this is a wrong mention of such punctuation because it does not fit here, as it is spoken. In this section, it is spoken of existing in a literally artistic or scientific work. What the Supreme Court was trying to tell is that the transfer of all or any rights in the copyright, in respect of any copyright, should be with respect to a literacy, artistic or scientific work. This punctuation was rectified in the Direct Tax Code 2010, which was appreciated by the Supreme Court, but which was, though not made formally which was not introduced. So this was not rectified in the Act itself. The another contention of the revenue was that explanation 4 that was introduced in 2012 to section 916 was a clarification in itself that if there is any transfer of all or any right for use or right to use a computer software, then it shall become royalty. Mind you that this introduction of 2012, this introduction of provision in 2012 was made with effect from the with retrospective effect, that is from 1976. Now the court went on to analyze whether actually you can have a retrospective effect of such provisions or not, and whether explanation 4 is a clarificatory nature provision or it is a explanatory or expansive provision. The apex court held that explanation 4 just expands the scope of royalty as per explanation 2 to section 916. It is not a clarificatory, it just expands the scope. As we are aware that till 2012 the right to use of software was not included in the definition, but from 2012 it was included. Now, the question of retrospective effect, the Supreme Court went to the extent of asking, can you impose or charge a person for those provisions which did not even exist at the time of Income Tax Act 1976? The apex court mentioned that the computer software word was introduced in the Income Tax Act only in the 1991, whereas it was introduced in the Copyright Act only in the year 1994. So how can you charge a person for something which did not even exist in 1976? So the Supreme Court concluded by saying that explanation for being an expansion of the word or the scope of royalty can be made applicable only from 2012 and not from 1976. Now, after understanding and analyzing the definition of royalty as per the Act, Supreme Court next took up the definitions to be analyzed and understood as per the Double Taxation Avoidance Agreement, in short referred to as DTAA. After comparing few of the DTAAs with whom, of the countries with whom the assessees, the various assessees have entered into transaction, like USA, Singapore, Japan, the Supreme Court observed that the definition of royalty in the Act is much wider than that of the definition in the Double Taxation Avoidance Agreement. How is that? The court said that at least on the following grounds, you can say that the definition of royalty is wider in the Act. It meant that the definition of royalty in the Act includes a consideration which includes a lump sum consideration. It includes the granting of license in respect of any copyright or any literary work, which is not. So these pointers are not available in the DTAA but in the Act. The Supreme Court did not stop itself by just analyzing Article 12 of certain DTAAs. Supreme Court went one step ahead to analyze whether the OECD Model Tax Convention should also be looked into for the ease of understanding and whether it should be considered for analyzing and concluding such transactions. Now, you all must be aware that the double taxation avoidance agreement are either take the form of OECD convention or of UN convention, right? So most of the Article 12 of the DTAA are in line with the OECD convention. OECD in the year, way back in the year 2008-2010, had analyzed or had understood that there is a need or there shall be a need for understanding the ramification of the softwares or the transaction with respect to the softwares, the royalty treatment, and hence in the commentary of the OECD, it was explained well in detail as to what shall be the end user license, what shall be the simplificatory use of right, what can be the substantial right, what can be the exclusive right, and so on and so forth. But when this commentary was introduced, countries like India and many other countries has raised certain objections, and India had certain reservations toward these provisions. But Supreme Court observed, though India had such reservations, no changes were made in the bilateral agreements entered by India with other countries. So the Supreme Court or the Apex Court concluded that because there are no changes in the bilateral agreements, we are going to consider that OECD commentary provisions can be made applicable to our to determine as to the nature or the characterization of the payments for use of software as royalty or not. Now, after understanding the Income Tax Act and Double Taxation Avoidance Agreement, it is very important to understand how do you apply these provisions. The intention was, the Supreme Court came up with the intention that the law's intention or the DTAA intention was to give certain relief, was to make the assessee fee enjoy certain benefits, not to punish them or to burden them. Which means that though you have a beneficial provision in the double taxation avoidance agreement, you cannot charge assessee with the taxation as per the Income Tax Act, provided the documents which are required as a compliance factor are complied with. So it was held that once the DTAA applies, or once the you need to compare the provisions of Income Tax Act and the Double Taxation Avoidance Agreement and arrive at a conclusion as to whichever is more beneficial to the assessee. If the terminologies used in DTAA are beneficial to the assessee, you need to go with, like as we discussed, as the Supreme Court discussed, that the definition of royalty in the Double Taxation Avoidance Agreement is narrower when compared to that of the definition of royalty, which means DTAA is much beneficial to the assessee and you should provide such benefit by way of Section 92. Now, Supreme Court, as I said, didn't restrict itself only with the provisions of the Act and DTAA. It went on to understand what shall be the impact, or what provisions should one keep in mind at the time. Provisions of Copyright Act should be kept in mind while analyzing and determining and concluding such transaction, which includes copyright related terminologies or transactions. First, we need to understand what is the copyright. So, copyright has been defined under the Copyright Act as an exclusive right. That is, this if a copyright is an exclusive right, it means you have certain restriction from doing certain acts. It is an intangible right. It also goes on to distinguish that if you're owning a copyright of a work, then it shall be different from that of the physical material which is available in the copyrighted work. So you need to keep in mind that copyright means either it is an exclusive right or it is an intangible, or whether the copyright is in a work which is different from the physical material which is available in the copyrighted work. Then the attention was drawn to specific provision under Section 14B, which relates to transfer of copyright in case of computer program. As we are discussing this case law because of the issue that arose whether the payments made towards the use of computer software should be treated as royalty or not, reference was made to 14B. 14B says that if the provisions as specified in 14A and rental provisions are satisfied or are complied with, then this transfer shall be treated as transfer of copyright in case of computer program. So, which means that there are certain rights which have been specified in Section 14A. If those rights are available in the transfer of the computer software, then it will be treated as transfer of copyright. What are the rights that were mentioned in Section 14A? The right to reproduce, right to revise engineer, right to decompile, right to access the source code, right to sale, or right to commercially exploit it or offer for sale of the computer program. Section 30 says that if the license that is being transferred provides you any of the rights as mentioned in Section 14A or 14B, then it shall be treated as copyright under the Copyright Act. So it is very important over here to understand when do you treat a transaction as a transfer of copyright. In other words, because of a transfer of license, if I get access to reproduce the software and commercially exploit it, that is to further sell the same, then this transaction will be treated as a transfer of copyright, which means the same shall be treated as a payment towards royalty and it shall be taxable. But if there is a license which I purchase, and if I have not been given enough rights, I have just been given the right to use as is, or I've given very limited rights so that I can open the software, I can use the software as per my needs, then in that case, it shall not be treated as the copyright. This forms the basis for all your discussion, for all your analysis. So once the Supreme Court concluded that what are the rights that define the transaction to take the characteristics of copyright or royalty, the Supreme Court went on to analyze the end user license or distribution agreement. As we discussed that there were more than 80 appeals which the Supreme Court had to decide on. So Supreme Court picked on a random basis few of the agreements, whether it is an end user license agreement or a distribution agreement, and came up with the common points which are available in those agreements. So it said, the agreement said that there is a non-exclusive, non-transferable license, there is no copyright available, the distributor is not allowed to use the software, use the product, the end user can use it, but he does not have any right to reproduce, revise engine, transfer, commercially exploit it, or whatsoever without the permission of the of the lender. So, if we go back to applying the provisions of Copyright Act, particularly section 14B, to the existing, when I say existing, to the current case where the end user license agreement and distribution agreement were analyzed, we can say that the transfer of license from the non-resident manufacturer or supplier of software to the Indian distributor or the end user does not partake the characteristics of the transfer of copyright as mentioned under section 14A, 14B of the Copyright Act. So here is the point that you have to analyze on a case-to-case basis. If you have any case before you, understand whether the agreement speaks or agreement, spells that these are the rights where the end user or the distributor can commercially exploit it, can reproduce it, or resell it. If they are able to do so, then the transaction shall be treated as royalty, taxable under Income Tax Act. If not, then it shall be treated as goods. Now, the revenue, in spite of all this, contended that the end user license agreement has a has termed that this transaction is not a sale but a transfer of license. So here we go back to the point whether you need to look at the transaction or look through the transaction. Now this particular terminologies has been discussed by the apex court in not only this decision but in various decisions including Azadi Bachao, including your Vodafone case. The Supreme Court reiterated that the real nature of transaction should be looked at and not looked through. The Supreme Court also analyzed or relied on its own judgment in case of Tata Consultancy Services versus State of AP, wherein the purchase of software in a floppy disk covered in a plastic, which is called a shrink wrapped or a canned software, was treated as sale of goods. Applying that case law over here, provisions of that case over here, it said that the license in the current case is a sale of physical object which contains the embedded computer program, and hence it is a sale of goods and not royalty. I repeat again, you need to distinguish whether the right what you get is a copyright or it is only a copyrighted article. Now let me take an example. I am an author of a book. I write a book. I get it published. I give only certain rights to the publisher that he can print and sell it. I I order 1,000 copies. He publishes and he sells it. This will not be treated as a copyright because I have not transferred the rights to reproduce it or to commercially exploit it. But on the other hand, if I allow the publisher to to reprint as many copies as he wants, not as per my orders, but as per he wants. So I am transferring my right to him, my exclusive right that I had on the book. I have transferred it. So he gets the exclusive right and he can reproduce it. So this gets reflected as per 14B that there is a transfer of copyright and hence this particular transaction will be treated as royalty. So individually on a case to case basis you need to understand whether this is a copyright or a transfer of copyrighted article. So with all these bases of judgment, it can be concluded that PILCOM case is not applicable. DTA can be applied at the stage of deducting tax under section 195. The provision, the terms of agreement as per the end user license agreement or distribution agreement do not create any interest or right in such distributors or end users which amount to use of right of any copyright. Okay. Explanation 4 to section 916 is the expansive provision, which means it expands the scope of royalty and it is less beneficial to the assessee when compared to DTAA, hence should not be considered. Explanation 4, which was introduced in 2012 to section 916, shall not have a retrospective effect but shall have a prospective effect as we discussed from 2012. Distinction need to be made between a copyrighted article and copyright. If you have limited right to use, then the same shall be treated as a copyrighted article. But if there is a right to reproduce, revise engine, access to the source code, you can commercially exploit it, resell it, transfer it. In all these cases, it shall be treated as transfer of copyright. In case of copyrighted article, it shall be treated as a goods as has been upheld in the case of Tata Consultancy Services by the Apex Court. So to conclude, that any payment made by the resident Indian end user or distributor to the non-resident manufacturer or supplier for the use of the computer software through the end user license agreement or distribution agreement is not payment of royalty. Same does not give rise to income taxable in India, as a result of which TDS was not liable to be deducted under Section 195 of the Act. This is going to be a very welcome judgment. Lot of the assessees are going to be benefited by this. Many assessees may just apply for the refund because they would have already, deducted the tax and remitted. But for sure, there are certain points which are still open as to whether the medium of delivery makes any difference to arrive at the to apply this case law. For example, what we discussed in this judgment was with respect to shrink wrap software or the cane software. But what happens if in the current scenario where everything is digital? So even if I need a computer software, I get on my email ID and just need to click and I need to download it on my computer. So whether this will be treated as a copyright or a copyrighted article. So based on the various analysis what we have just done, though it has not been specifically covered, but again, the mode of delivery or the manner of delivery will not matter. What will matter is, even after you downloading the software, do you have all the rights or do you have non-exclusive, non-transferable rights? So you need to be careful, irrespective of the mode of delivery. Only the rights which have been given as per the agreement need to be looked into to conclude whether the same shall be treated as royalty or not. As in this case, the payment towards the use of computer software is not being treated as royalty. But it is like one, you have just escaped from one provision, but with effect from, and you have fallen into another. What do I mean by this? With effect from April 1st, the equalization levy has been introduced, which says that 2% shall be charged on the goods supplied or services provided by the non-resident to Indian users or Indian residents through a digital platform. Now there was a clarification in 2021 which said that the payments towards royalty or fees for technical services, shall not be subject to equalization levy. Now, post the landmark judgment, what I just discussed, payment towards the use of software is not royalty. So if I go back to the clarification given with respect to equalization levy 2.0, software license fee or payment towards the use of license or towards the software license is not in the nature of royalty, and hence you need to ensure, does it fall under the provisions of equalization levy. So this is something food for thought. We need to still see because it has been recently made applicable and the judgment just came in March 2021. So considering all these scenarios, one cannot just get relaxed, okay, I'm not liable to TDS under 195. But you have to see whether the other provisions like utilization levy is still applicable, and you need to take steps according to the provision mentioned. With this, I come to the conclusion of my presentation. I would like to thank CA Sansaar once again, Vivek sir, and the entire team for giving me this opportunity and managing everything so well. In case any of you have any queries, in case you need any clarification, you can connect me on the number given, or you can email me, or you can even, post a comment on this video. I would request all of you to subscribe to the CA Sansar channel, because in this pandemic time, it shall be very useful and you can update your knowledge accordingly. Thank you so much for listening to me. Thank you.